Okay, I'm going to get started because we're already a few minutes late and we have lots of interesting things to discuss. So this panel is called Antitrust Policy Issues, which is, could describe anything. Reminds me of my son's papers that he submitted during college, which were all called ropes of sand. Literally. Anyway, my name is Eleanor Hoffman. I'm Deputy Chief of the New York State Attorney General's Antitrust Bureau, and I've been there 15 years. I've done all sorts of antitrust cases. Prior to that, I was a partner in a large law firm called Adair Brothers, and I've practiced antitrust for most of my career. I have to make a disclaimer. Anything I say today does not reflect the opinions or views of anyone in my office or the Attorney General. And I think the format that we'll follow today is I'll briefly introduce the topics and then introduce the speakers for each paper. So in this section of the program, we're really going to be looking at antitrust policy issues and the intersection with the digital world for the most part. Our first paper deals with remedies, so we're starting at the back end, kind of. And the paper analyzes the history, policies, and practical considerations associated with post-closing merger breakups, and particularly those that have cleared the Justice Department and the FTC. And in particular, the author, Professor Patel, looks at breakups of firms, for example, Facebook, Instagram, Google, DoubleClick, so those that have made the news lately as firms that possibly could be affected by investigations, and the remedy could be a breakup. Our second paper by Professor John Newman will examine the role of attention-seeking firms in the competitive marketplace and discusses the need for antitrust to pay more attention to attention. I really like that line.
No, you can't say it. Now you can't say it. Yeah, you know,
Oh,
stop.
sorry.
Still say it. That's all right.
You
We'll get it.
But that is Professor Newman's line, not mine.
Thank you.
And in particular, Professor Newman distinguishes between attention-seeking firms, think Google, Facebook again, and two-sided platforms, a subject that I think is very interesting. Our third paper by Professor Zaldokas looks more broadly at the relationship between executive compensation schemes and incentives to collude. And he looks at the links between, for example, the closures of DOJ field offices that happened in 2013, changes in compensation structures, and indications that firms might be engaging in collusive behavior. So let me introduce the author of the first paper and the discussant. Professor Manesh Patel, the presenter of our first paper, which is called Merger Breakups, is acting professor of law at the University of California, Davis School of Law. His research interests are in antitrust and empirical corporate and securities law. And in addition to the issues discussed in his paper, Merger Breakups, Professor Patel's recent research relates to the proper antitrust treatment of common ownership. In addition to his JD from Stanford, Professor Patel has a PhD in economics from the University of Wisconsin, and he also practiced in the private sector. The discussant for that paper needs no introduction, but I will anyway. Scott Hempel is the Moses Grossman Professor of Law and co-director of the Engelberg Center on Innovation, Law, and Policy here at NYU. He teaches and writes about antitrust and intellectual property. He also has both a JD and a PhD in economics. and his research focuses on the law and economics of competition and innovation. Professor Hemphill has also served as Antitrust Bureau Chief, where I had the pleasure of working with him at the Office of the New York State Attorney General. Okay, Professor Patel.
Great, thank you all. One of the most pressing current antitrust policy questions is whether and the manner in which antitrust should be used to sanction the conduct of large technology companies, Google, Facebook, Amazon. And within that larger question is a subset question, which is, should the antitrust laws be used to dismantle or break up those particular companies? And a vigorous debate now rages within antitrust policy circles, and academics, commentators, and policymakers have advocated a wide array of policies that are intended to address what should antitrust, if anything, do to break up large technology companies. This is a unique moment in antitrust where a large chorus of voices has come together to provide solutions to what is considered to be the antitrust of concerns of big technology. I guess if we're here, we can say we've entered, I think, the next generation. So three basic policy proposals have been announced, and one is large-scale Section 2 claims against technology companies by the agencies where the remedy sought is structural reform, or breakup, or other some sort of structural relief. Second is legislation, where the legislation will do something to the market to alleviate some of the antitrust harm. So, for instance, proposals that would prohibit platform-based companies from also operating on their own platforms. Amazon could operate a platform, couldn't sell its own product on its platforms, is one example. And then the mechanism that's proposed, that is the object of this current paper, which is that the agencies challenge and seek to break up key mergers in the technology space. So what are the ones that often make the list? Those are the biggies, right? They're the ones that sort of form the tech landscape. Proposals to break up Facebook and Instagram, Facebook and WhatsApp, mergers, acquisitions by Amazon and Whole Foods, and Amazon and Zappos are often cited as possible examples for breakup. And then there's a suite by Google, right, that they viewed from way back. Google DoubleClick seeks to propose to be Unbound, Google Nest, and Google Wave. Each of these transactions, of course, is very different, but with one exception, there's a common thread that runs through all of them, and that each of them, save Google Waves, was reportable under HSR, reviewed and cleared. I don't go through the list, we all know about them, but for instance, Facebook, Instagram, right? Subject to HSR, agency took a good hard look at it, ultimately cleared the transaction with no limitations, transactional code. The arguments that these specific mergers that went through the HSR regime should be revisited and investigated and challenged implicates a much more fundamental antitrust question that is the object of the paper that I evaluated. And that fundamental question is, should the federal agencies increase the extent to which they challenge mergers that they previously reviewed? Now, there are strong theoretical reasons as to why we may want that. Most notably, HSR review is an ex-ante predictive exercise. We do not see the effects of a merger, but after a merger closes and proceeds for some time, there's evidence to evaluate actual competitive effects. On the other side, as I'll discuss in a little bit, there's strong reasons why we want to be a little concerned and wary about an unprincipled increase in these forms of ex post challenges. So the paper systematically evaluates the case for additional agency challenges to acquisitions and other transactions that the agency reviewed and cleared. And the paper offers a qualified affirmative answer to that question. So the paper argues that the agency should do that, right? That they should amplify the number of challenges to previously reviewed and cleared mergers. And here's the qualification. And the qualification is that they should do so in a way that respects the significant mitigating factors that are associated with the expansion of those types of ex post challenges. And to implement that latter requirement, that is a limiting condition, the paper identifies two necessary conditions that it argues ought to be met before the agencies challenge any particular merger that has gone through the regulatory wheel. So I'm in front of a sophisticated antitrust audience, so I don't need to get into any of the details of HSR, but let me just flag two of them to frame the conversation. First, as we all know, that merger review in the context of Hart-Scott-Rodino is a predictive, entirely predictive exercise, right? It happens before the merger actually proceeds. So we have a lot of solid econometric tools that many reviews are comfortable with, but it is still a predictive exercise. The second sort of ground clearing point is that as a purely legal matter, agencies are not precluded from revisiting a transaction that they did or did not take action to pursuant to a Hart-Scott-Rodino. In fact, HSR itself envisions this particular process and that provision that loosely says that agencies do something again, despite what they did before. The time of suit doctrine is also important in this area. So I want to put that out there. And then that proposition announced by the Supreme Court in DuPont says loosely that when challenging a merger, the agency can rely on market conditions at the time of the acquisition. At the time of suit rather than the time of acquisition. So if they sue, I suppose, they can use market conditions as they existed at the time. So the paper first argues that there are compelling, strong reasons as to why an expansion of ex post challenges would increase consumer welfare, advancing aims of antitrust. And to start, there's a bunch of theoretical justifications why we would want to have the agency revisit mergers that they previously reviewed and cleared. And so perhaps most notably is the point that when the agencies do merger review in the context of HSR, they have limited data, limited time, limited tools, and so as hard as they may try, they're going to get the answer wrong in certain instances. And even in like this beautifully hypothetical world where there's infinite data, infinite time, and infinite tools, there's still going to be some uncertainty because the process is stochastic. So sometimes they're just going to get it wrong. And that opens the door to intervention because if the agencies are not getting it right, then there's something to be fixed as opposed as well. So that's all fine and good. I think the more interesting is so what evidentiary support do we have for that? And there's a few things one can draw on. And merger retrospectives provide a fine opportunity to support the expansion of ex post relief. So what are retrospectives? Well, we know what they are, is that they are studies done by economists, both agency economists and academic economists, that seek to evaluate specific mergers after the fact, using after the fact data to see did those mergers generate all the policy, including mergers that were cleared by agencies and subject to remedial relief. And sure, there are retrospectives that find no competitive effects and maybe positive effects, but as I sort of go through the paper, the bulk of retrospectives that have been done show that the mergers that are under consideration went on to generate competitive, even though those were perhaps cleared and subject to conditions post-clearance as well. So what to make of those implications? One can do many things with retrospectives, but in terms of this particular practice, provide evidentiary support for ex post relief, right? Because if we're seeing compelling instances of the agencies getting it wrong in the sense that there are anti-competitive effects after the fact, that substantiates the need to do something ex post. But I guess just like everything, there's another side to the story. And the other side of the story is that there's many reasons why we want to be cautious about an unprincipled and unbridled expansion to ex post challenges. And one of the foundational points that helps sort of think through this is to observe that if the agencies are going to challenge mergers that have gone through and been cleared under HSR, those challenges are going to occur almost always with respect to mergers that have been consummated, right? The matter is clear, the parties close the deal, then after the fact. So what this means is that all of the things we know about why agency challenges to consummated mergers are bad apply to this particular analysis as well, because these challenges are going to be to consummated mergers. So there's a bunch of reasons why we're sort of hesitant to challenge consummated mergers, and there's a bunch of reasons, and perhaps the best is the remedies issue, right? That if you challenge a consummated merger, the assets and operations are commingled, it's hard to find the lines to separate the party, the eggs are scrambled, blah, blah, blah. Competition may not be infused into the market as well. There's additional reasons as well. So this latter point was about the relative merits of ex post versus ex ante, but the argument could still be, well, it's still, ex post still maybe do something, right? Ex ante is better, but ex post can get us somewhere still, but maybe not as good. But there's still reason to be a little bit hesitant here too, because there are some trade-offs as well, because an expansion of ex post relief could mitigate the effectiveness of ex ante relief, and we believe that ex ante relief is better, right? There's obvious resource constraints as well. Yeah, agencies have a finite pool of money to work with, they're going to pump into ex post and have a trade-off to ex ante. There's also an incentives function as well, right? The agencies know they're going to get sort of a second bite at the apple, then maybe they're going to take a less robust bite the first time, right? And so there's that sort of channel through as well. And then we just spend some time talking about disrupting the finality of the merger review process, and we've talked about that, we really know that means as well. So what that discussion shows is that on one hand, there are reasons why, strong reasons why we want to allow the agencies or encourage the agencies to do more of that. What is that? Revisit challenge mergers that they themselves view clear, but we want to be a little circumspect principle about that. And so Taylor argues is that we should take a look and search for some limiting conditions to have an increase in ex post challenges. In the case that I argue we look at are sort of key points where we would expect benefit and harm. And first is with respect to the case that has been made for ex post intervention. What does the agency's evidence have to say? And then the second factor is with respect to the remedies plan. Is there going to be an appropriate remedy? So the agency should challenge, but and here's one of the limiting conditions that argues the agency's evidence when they're sort of seeking to challenge, the preponderance of that shows that the merger is going to do the thing that we don't want to do, or substantially impair competition. Trains the analysis on what the agency see and believe that is happening with respect to that merger, but requiring more than a supposition or de minimis evidence. Evidentiary requirement. The second requirement looks at the remedies, and the second condition is that the agency should challenge only if there is a remedy that they reasonably believe is going to alleviate the competitive harm that they've identified. Now, keep the point on that is as a general matter, because of the suite of remedies that are available, that factor is going to be met as a general, just generally going to be met. But however, an appropriate remedy may not be structural. In particular, it might not be a breakup, and that is more plausibly the case for some of these mergers that are now teed up for exploitation in the tech sector that have been consummated many years ago. So the structural root may not get it there. And furthermore, the competitive harms that have been purported to be caused by those mergers may not themselves be amenable to structural relief, and may require conduct relief as well. The point is that there should be a remedy. There will be usually, but it may not be structural, may not be a breakup as well. Two other considerations, just to sort of wind down my comments, is that first is that the limiting factors only relate to ex post merger challenges. We're not talking about, for instance, Section 2 suits, like not related, but there is an interesting question about Section 2 suits that are predicated on the acquisition, where the exclusionary conduct is the acquisition, which is stuff that Scott has written on, and so this sort of analysis sort of feeds into that world as well. And the other point is that the limiting factors are necessary but not sufficient conditions. So what does that mean? That means there may be other reasons why, even if those conditions are met, the agencies may seek to not challenge the merger in any of that. And so what that means to me, and how I sort of view that, is that I consider the paper not to sort of answer the questions, but to sort of provide a start to the conversation. There are some limiting factors, maybe there's more, and we'll go forward in that way. So thank you for letting me make those prepared remarks, and thanks to Scott in advance for his commentary on my paper.
Great. Should I come around?
Sure.
So thanks a lot to the organizers for the chance to talk about this terrific paper. I really enjoyed it. It's it's tackling an obviously important issue, one that's much on the mind of many of us here who are thinking about antitrust enforcement for big tech. It makes some very nice points that you've already heard Manesh talk about. Effectively, I think makes the point that sometimes waiting is beneficial, right? That there's something to be said for ex post rather than ex ante enforcement. Is fully cognizant of the desirability of some limiting principles so we don't run roughshod over every completed transaction that's ever been cleared, and has, I think, some important practical upshots for real-world enforcement. So, I want to offer, I guess, 3 comments here. One, about those limiting principles, both, playing with them, pushing back on them a little bit, and also thinking about some opportunities to expand the analysis. Second, talk about something that I found just fascinating in the paper, this discussion of, I think you described them as exogenous competitive effects. We might think of them instead as kind of supervening causes, later actions that cause us to blame not the transaction but later events for some competitive problem. And then third, to think a little bit about how tech is or isn't different from the bread and butter merger retrospectives that are familiar to a lot of us from a fairly thick literature in this area. So first, with respect to the principles, the first principle, as Manesh mentioned, is there a preponderance of evidence supporting an anti-competitive effect? Now here I wonder a little bit, how much is this really going to constrain at the end of the day? The caricature is that it's basically a mandate to only bring the good cases, don't bring the weak ones. So I wanted to hear a little bit more about, look, if you have a solid, uncontradicted merger retrospective showing a, 7-10% price rise, a lot of these retrospectives show something like that, is that enough to go bring the ex post challenge? Again, assuming that the remedy principle is satisfied and you otherwise have capacity in your agency to go do that. I think the answer might be yes from the analysis. Now, if the answer is yes, on the one hand, I'm a little bit skeptical how much of a practical constraint this particular principle provides. On the other hand, it gives you a very strong practical policy upshot, right? One that you'll be attacked for, but one that in terms of the splash of the paper, it would give it some oomph, right? You would say, look, the Miller-Weinberg retrospective on Miller-Coors is pretty strong. We either can or can't go look at that. I mean, I don't know how integrated Miller and Coors are now, but they still have both names in the name. So the question would be, can a state AG, could a private party, could even DOJ go chase that, right? And that would be of a piece with, your recognition that, we say clear, but it's not like we've actually given it a full bill of health as enforcers, right? It's still open to go pursue something after the fact. Whatever the answer to my question, I think I'd make it explicit. Second, your second principle on having a good remedy, you caution that we shouldn't act if a good remedy is absent. And I take the point that merger remedies ought not be punitive, right? What I didn't see in the paper was quite enough, for my taste, discussion of deterrence, right? Do we think that that's off the table as a basis? Because we could do injustice in the small, right? You could make a hash with a terrible remedy in a particular case, and yet we still think there would be some salutary deterrence effects. And so some of those larger benefits, which of course is part of how we think about the optimal design of rules, I think is worth mentioning. Either to say, yes, you can include it, or you can't, or I think it's big, or I think it's small. It seems like at least acknowledging that issue would be valuable. As you mentioned, Section 2 shows up in the paper, I think, kind of briefly. I do think, given your interest in, for some of your transactions, not all of them, big firms buying little firms, Section 2, maintenance of monopoly, is worth talking about. As you mentioned, I've done some writing on this individually in a new paper with Tim Wu. I think there might be some more to be done there. On the second point, exogenous competitive effects. I thought this was fascinating. I think you're making progress on this in the paper. Your example of, well, let's think about a Maverick that exits after the merger. You can't blame the merger for the exit of the Maverick. Or, assuming you can't blame the merger for the exit of the Maverick, that would be a competitive effect that's not attributable to the merger. And so, even though there's a harm, maybe a harm that wouldn't have arisen had they not merged, that what I take to be sort of the later acting exit could make could make a real difference. I mean, I think about this as being a question of, fundamentally, a question of causation, right? Whether there's some kind of intervening or supervening cause that's kind of cutting off how we should think about the, by then, attenuated effect of the merger. I'd love to see more on that, right? I don't know how far along the paper is from your standpoint, or whether you're going to develop it further. I think it's a really hard problem that a lot of people are struggling with right now to think about. I mean, it's partly a question of, information as it facts as they existed on the ground at the time of the merger versus later. But there's also just this question of later developments. Can we count them or not? When can we count them? Does it matter, for example, as to the Maverick, whether the Maverick's exit was foreordained before the transaction, or whether it was the happenstance of, let's say, death of a founder or something that we could think of as being, a sort of bolt of lightning after the transaction? Are those different situations? I think there's a lot you could do to help us think about this kind of problem. Third, on tech mergers. So, for those of you who haven't read the paper starts with tech mergers, right? Facebook, Instagram, and a bunch of others. Ends with tech mergers. And then a lot of the material in the middle, I think, is about ex post challenges to mergers more generally, which makes sense, right? If you want to take advantage, for example, of the literature about merger retrospectives are about beer, right? Clearly horizontal transactions where we're looking for price effects tend not to be tech transactions. And so what I'd love to see more of in the paper is doing more to fit some of that machinery in the middle to the specific case of tech that motivates you, and I think that people are thinking about right now. And sort of wrestle even more than you do with the ways in which that material either is or is not apt for thinking about tech. And whatever the answer is in terms of aptness, I would be explicit about working that pure. A couple of ways I can think of where some of those merger retrospectives and more generally our traditional thinking about ex post challenges to horizontal transactions might need to be adapted or even thrown overboard when it comes to Facebook, Instagram, for example. I could think of a few. I think all of them sort of pivot around an idea that fundamentally we're talking about nascent competitors. We're talking about competitors who are not yet really competing in the market. They might ultimately be competing for the market, but they're not there yet, right? They're Netscape vis-a-vis Microsoft, right? Netscape had not become an operating system competitor. Not clear it ever would have been. Right? It was a nascent threat. The word nascent we use repeatedly in this discussion because the word seems to sort of fit, but also because the DC Circuit said it. They have some famous language about how nascent competitors, if they're squashed, are something that antitrust does, must care about. Now, where this sort of plays out, and I should say this, some of what I'm about to say is just basically cribbed from this ongoing work with Tim Wu that I think sits adjacent to Manesh's project. One is that you shouldn't be looking around for a bump in prices, right? The benefits of ex post analysis here are not that, oh, they merged and then we saw, Facebook raise its price by 10%. It's not just that there's no monetary price, because you could have an advertiser side price. It's not just that, we just have to think about privacy and then we can see the worsening of privacy over time. It's that the but-for is just different, right? In your average horizontal transaction, you got two firms that are both selling something, and now there's just one, and the reduction in constraint allows it to have some kind of step increase, let's say, in price. Whereas in these nascent competitor cases, we tend to be really caring about maintenance of something, not acquisition of something, maintenance of an existing position, the removal of this nascent threat that allows you to kind of continue on your path. And so what's unobserved is that but for a world where you might have had competition, albeit only with some probability. So what we're going to go find, thanks to our ex post analysis, is something, but it's not going to be a bump up in prices. Now, I don't think that means take out the discussion of merger retrospectives. I think it's powerful and important. But I think when we come back to the tech example, we have to think about what we gain. And I think what we gain is not so much the price bump up, but not so much direct observation of an anti-competitive effect, but sideways things, inferential things. Maybe we learn something about the intent of the parties that comes to light. Or maybe we learn something about the durability of market power, right? That's not impermissible hindsight bias to say, gosh, in 2012, it looked like Facebook had a lot of competitors. Turns out we didn't really understand the market very well. And it turns out that that market power is durable, right? Or it turns out that some claimed efficiency, this is one that does carry over, right? A claimed efficiency that the agency thought, I don't know, maybe, turned out not to come to pass, right? That would be one that you talk about that I think does directly come over. But thinking through what can be brought over to the tech context and what can't, I think would be an obvious thing to go do next. Thanks.
Okay, Danny, you said that you liked active moderators. Can I just make one observation? When I was reading your paper, Manesh, it occurred to me that the two conditions that you pose are in tension with one another. So in order to develop a preponderance of the evidence that there are bad effects after the merger, that takes time. And the longer you wait, the longer the investigation is, the more difficult it is to find a remedy. Because a remedy that won't cost consumers as much and a remedy that makes sense. And I think this was highlighted in the Evanston case, for example, which came after a retrospective, which was a horizontal situation. So I just make that comment.
Thank you.
Okay. Second paper is by Professor John Newman, and it's called Antitrust in Attention Markets. Professor Newman is Associate Professor of Law at the University of Miami School of Law and a fellow with the Thurman Arnold Project at Yale. Prior to academia, he was in the honors program at the United States Department of Justice Antitrust Division. And his recent scholarship focuses on zero-price markets, platform markets, and pro-competitive justification analysis. And his current work in progress is entitled The Output Welfare Fallacy. Professor Newman?
All right, thank you so much. And thanks to the organizers. It's a pleasure to be here. I'm looking forward to everyone's comments. This is a baby draft paper, so any feedback is very welcome. So the paper is titled Antitrust in Attention Markets. And the focus of it is kind of these things that you see up here, right? They tend to be zero-price markets. And what goes on here is some kind of exchange of access to some application for, I would argue, our attention to advertisements. And you can get at the rising importance of these attention markets a bunch of different ways. One would be to look at global ad spend, which just increases and increases and increases year over year. David Evans did some estimation of like what is the value of time that we U.S. adults spend on advertising supported media every year. Apparently it's 437 billion hours, and depending on what metric you use, that could total up to trillions of dollars worth of time and attention that's being spent on these markets. So that's, argue, a very important and becoming ever more so every day type of market, and we in antitrust circles should be paying attention, there it is, to attention markets. All right, I'm not going to say that's the only pun I'll work in, but I'll try to limit it. So a quick roadmap of what I want to do here is first just talk about market definition, a core concept of modern antitrust, make a couple arguments around choice and welfare and the idea of air quotes free and real free, then make a maybe provocative argument that I think attention is actually much more important than data, and then wind up with maybe the most provocative argument, that is, we should allow some activity that looks like cartel stuff in these markets. So with that, market definition. And the first question I wrestle with in the paper is, are these two-sided platform markets. They are often referred to as such, I would say ubiquitously. These things are thought of as platforms. Now, this question becomes very important when you think about the specter, the looming specter of Ohio v. American Express for actual litigants in the room. So this is how people tend to think of these markets, and if that's true, maybe that runs into Amex problems, and Amex is a real problem if you're a plaintiff. Great if you're a defendant. I don't think this is right. I think this is wrong. And the way I get at this in the paper is to suggest that we think of defining two-sided platforms in a different way than most economists offer. I say we should look at the consideration, right? The thing that's being exchanged. And if we can trace it all the way through a distribution system, right, chain, in this case it would be a car, then we're dealing with a traditional top-down vertical distribution chain of the type that we're all very familiar with, right? This is not a two-sided platform. The reason I argue is because you can trace a car all the way down. You can distinguish that from, say, a payment network, right? So a payment network is offering different things to different customers or trading partners, and you can't trace those things all the way through a distribution system in the way that you can with a more traditional market. So this, I'd say, yeah, is something different. Query what that means for antitrust policy, but it is maybe something different. So that's a two-sided platform. Is this a two-sided platform? Antitrust people kind of started thinking about this maybe 10 years ago, let's say. And for a while, we weren't quite sure what users, all of us in the room, were offering to companies like Facebook. In fact, a lot of people just said, oh, Facebook is free, so there's no market here, antitrust can't apply. I think we've moved past that, and we're recognizing that, yeah, users do trade something to Facebook in order to get access to the platform. One of the things we trade is our eyeballs to advertisements, right? Well, it turns out when you swap in eyeballs for that question mark, you can actually trace the eyeballs all the way through the distribution system, and this starts looking much more like a familiar top-down chain that we're all very familiar with, right? We produce stuff, it's called attention. We then trade it to an intermediary, a distributor, Facebook, which then resells that product to the ultimate consumer, which is, of course, the advertiser, getting to a question that was posed earlier. Yes, I think advertisers are the consumers in these markets. Okay, question number 2 then, with that in mind. Are attention markets really, really big? Are they super, super competitive as a result? The argument is made that, well, if it's just a market for attention, all these different companies compete for our attention. And even we could go farther and say, live sporting events compete for our attention. Of course, crying children can grab our attention, on a plane especially. Beautiful sunsets, beautiful people maybe. Why not throw it all in there and say this is a huge market, so nobody's dominant, so there's no antitrust problem. Unless you think I'm setting up a straw man, here's actually the beautiful sunset argument being made, not by a random person, but an actual antitrust person on Twitter. I blacked out who they are, but you can find it if you're curious. So that's the argument. I think this is not the right way to think about this. The standard is not does anything compete with anything, and if so, then it's in the market. The standard is it reasonably interchangeable, right? If so, then it belongs in the market. So if we're trying to figure out whether we've got a social network market, for instance, and we're wondering whether crying children belong in that market, we don't ask, do they compete for our attention? We ask, are they a reasonable substitute? Right? And I think no matter how we chose to define the market, whether that was what I offer, that's a SNCC test, small but significant and non-transitory increase in attention cost, or whether we use practical indicia like functional interchangeability, whichever path we choose, I don't think we're going to include crying children in our market. Second point, I'll make this one quickly. That is that increases in consumer choice are not necessarily synonymous with increases in consumer welfare, even though we often talk about consumer choice as if it's pretty much the same thing as consumer welfare. There's a bunch of fun research around like behavioral economics, consumer psychology, that suggests, no, actually sometimes when you increase the number of choices that are available, people do not make welfare-enhancing decisions as a result. We've all been to the restaurant where the menu just has way too many options. It's overwhelming. This is why Chipotle works, right? There's just very few options. It's very easy to get in and out. And sometimes that's actually helpful to a consumer. Third point, I've made this one like sort of ad nauseum, so again, a quick point. No, these things aren't really free. We are actually exchanging something of value to get Facebook, Milton Friedman would say if you're in the room, there's still no such thing as a free lunch. Fourth point, I think attention is actually much more important than data. Why? Well, in a zero price market, users exchange at least two things to a company like Facebook: attention and information. Some people look at this and take a very data-centric view, and this would be an example of that. The business model is to get data and sell it to advertisers. I think this is incorrect. This is how the data-centric view would have us believe these markets work, right? The data just flows downstream. My question is, why would BMW just want my data, in particular my Facebook data? Why would they want to know that I'm like messaging an ex-girlfriend? Are they just sort of evil supervillains cackling once they know that John's out there messaging his ex-girlfriend? No, of course not. They don't just want data. What does BMW ultimately want to do? They want to show me ads. Now, they may want data as an input to that final finished product so that they can like narrowly deliver their ad. But ultimately, they want my attention. They want me to see the ad. So the demand for data is just derived from the more central demand for attention. But what we've been doing is focusing a lot on data, I think, and not enough on attention. So why does BMW want our eyeballs? They want to deliver ads like these to us. So what normative prescription do I offer? Well, for one thing, I think we in the NHS community need to start talking about attention more. I'll say again, we need to pay more attention to attention. And this is my very scientific representation of what we've been doing. I think we could, if not invert it, maybe bring those two a little closer together. All right, finally, why might cartels be good? We'll try. Try to rehabilitate cartels. The first point to grasp here is that attention is scarce. That's important. It can be sort of overloaded over time or overloaded at any one given point in time. So think about it like a car. We can run out of gas or the engine can overheat from overuse. And what happens when our attention gets depleted over time? Not good things. We start making even more suboptimal decisions. We are easily persuadable. And in fact, we actually tend to exhibit more pronounced racial and gender biases. So we turn into not a good version of ourselves when we're in this state. Which leads me to suggest that attention markets are very prone to failure in unique ways. So normal transactions, let's say we've got a car market and a cheeseburger market. We can view those separately, and there aren't a lot of like externalities that flow back and forth between those two markets, which is nice for antitrust analysis. Attention exchange is a lot messier though. So what happens when I get on Facebook and I get bombarded by a bunch of ads and I spend a lot of time on Facebook, and eventually I turn into that less good version of myself? Well, let's say that we split Facebook into, so building on Manesh's paper a little bit, split Facebook into Facebook and Instagram once again. And Instagram now wants to show me an ad from, say, Carl's Jr. Turns out I might be in the exact state that Carl's Jr. and Instagram want me in, right? This not good version of myself. So there are these weird kind of almost positive externalities, this kind of feedback loop that I think can happen. And these markets end up looking not like we expect. Or Instagram might actually be happy that I've spent a bunch of time on Facebook, as might Carl's Jr. So what can that end up doing? Well, first, I might walk into a Carl's Jr., do the thing they want me to do, which is to buy a much bigger and more expensive cheeseburger than I intended. Second, I might walk into a totally unrelated store and buy something I shouldn't eat. Third, again, I might exhibit more pronounced gender and racial biases. These are problems. How could we stop them? One way might be through cartel work, essentially. And in it was 1978, the DOJ actually sued the National Association of Broadcasters for fixing the amount of ads that could be played on TV. DOJ brought this as a per se case. It looks like classic cartel output reduction. And a court kind of basically went along with that. I would argue that that's probably inappropriate treatment though, right? This should be treated something more like a Cal Dental, more like a BMI, where it's got horizontal coordination, but it's fixing some kind of market failure. So maybe it should get full-blown rule of reason. At the very least, DOJ should use some prosecutorial discretion. Surely they have better things to do than to make sure I have to see more ads on TV. And with that, my last pun, thank you for your attention.
Harry, before you start, I want to introduce you because I neglected to do that before.
Where I am.
So, importantly, Professor First is Charles Dennison Professor of Law at the NYU School of Law and co-director of the law school's Competition, Innovation, and Information Law program. Even more importantly, he also served as bureau chief of the Antitrust Bureau of the New York Attorney General's office from 1999 to 2001. So you have to realize that that's the third former bureau chief you've seen today, with James Hymes being the other one. Professor First's teaching interests include antitrust, regulated industries, international and comparative antitrust, business crime, and innovation policy, and he has written very many articles, one of my favorites is called The Democracy Deficit, I believe.
Yes.
Very good. And his most recent scholarly work has focused on various aspects of antitrust enforcement and theory.
Thank you, Eleanor. And thanks to the conference organizers for inviting me. I am one of the conference organizers. It's always good. One of the hardest things about making comments on John's paper is for a law professor not making bad law professor jokes, like pay attention to what I'm saying. So I'll make a French one. If we were in Paris and we were talking about this in French, we might say, faites attention, make attention. And that's exactly what John argues. It's not paying, we're producers. I don't know what that helps, but I thought it was a little sort of French joke. This is a very enjoyable paper, and I always find this is actually the second time I've had the opportunity and privilege, actually, to comment on John's papers here. He will soon be a former, a last-gen person, but for now he's a next-gen person. I always find that after I dig into the papers, it always gets me thinking, and this one does as well. I don't always agree, and there's some things that I don't agree with in the paper, but it does set up a provocative thesis. And what I want to do is just, in a sense, do in part what John did with his slides, situate the paper and what the problems are that I think he really wants to address. Then discuss some of my concerns and questions about the paper. Say a few nice things, of course, about the paper. And then what John doesn't want to hear is the things I think he should do on the next draft, because whoever wants to do a next draft, right? You just want to fill in the footnotes and go on to something else. I know this very well, but anyway, I'm going to suggest some things. So the first slide actually tells you, obviously, to situate this, what we're really concerned about. And what I think a lot of people in this room are concerned about, which is the power of the big tech platforms, and trying to figure out how antitrust can get a handle on what is a major policy problem that many people have focused on, and people who are not antitrust professors or even antitrust lawyers, but are concerned about the power of 4 or 5, depends on how you want to count them. I like to count 5 as the frightful 5 big platforms. And, there's so many data points for it, but 4 of those 5 companies have market caps over $1 trillion. Facebook actually is below that. And Microsoft is one of the 5, by the way, in case you've forgotten it in the rush to, all the other new ones. But so these are major players in our economy. They have, Amazon just announced its last quarter sales over $80 billion. If antitrust doesn't pay attention to this, it's not paying attention to anything. So I think John's paper comes out of this. How is there a concept that we can bring to this problem that will help us? I have to put in a plug for a conference and other John had that conference slide. So we're going to have here on February the 28th a conference on antitrust and 21st century bigness, focused on tech platforms. It's free. I mean, well, you have to pay attention for a whole day. But it's attention to antitrust matters, so that's like a benefit, and it's going to be a very good conference. Representative Cicilline is going to be our keynote speaker, so I think I urge you to come. Anyway, so starting with the main concept of the paper about attention, that attention is scarce, and it's our attention that these platforms want. They want us engaged in the platform. It's not just looking at it. They want engagement. They want us to stay on their platform, interact with it, and do whatever that platform offers us, whether it's social networking, whether it's Amazon and products, whether it's Google and search. They want us engaged. So this is intuitively, I think John's argument that attention is important because it is describing what their business model is and what's important. One of the interesting things I started thinking about it is the concept of attention, if we're really going to use this in competition analysis, is both over-inclusive and in some ways under-inclusive for the problems we're worried about. So over-inclusive, I think, in senses that John recognized. There are lots of things, do I say the word competing for our attention? That has another sense of it, but a lot of things that demand us to pay attention. As teachers, we want our students to pay attention. Parents, we want our children to pay attention. They don't. Ministers want us to pay attention when we pray. Mystics want us to pay attention to cosmic things. So there are lots of things that demand our attention. We just bought a new car, and it demands my attention because it beeps when I get a little too close to the side, and it also, on the navigation screen, I get my emails and text messages. Pay attention to me, says my car. I mean, it is all over. So in some sense, it's a broad concept. John focuses on advertising as a way of getting our attention in a way that gets monetized. But there are lots of ways in which sellers get our attention that doesn't involve advertising. So they might have attractive stores to attract us in, offer products that are aesthetically pleasing. Brand identification is a way of getting our attention to buy their product. So it's a very broad concept. I'll talk in a minute about how I think John usefully tries to narrow it down. And it's also a nuanced notion. So although our attention is limited, we all know that we chop it up. We call it multitasking, or not paying close attention and doing a lot of things at once. So the concept that it's a limited resource is, has to be looked at carefully. So the under-inclusiveness for purposes of taking on these major tech platforms is that a lot of the issues we're going to be worried about actually are things that don't demand our attention. In fact, they are useful because we don't have to pay attention to them, and this whole concept may not be useful to that. So the Internet of Things and sensors is about technology that we don't have to, that does not involve attention. The whole idea is that we don't have to pay attention to it. Our Nest thermostat is going to keep our house warm or cold. Autonomous vehicles are going to drive our cars. We won't pay attention. So for a whole range of technology that's coming, that these platforms, Google is going to have, I can't wait for this, with Nest and all of the technology, houses that you can live in forever because they will take care of you. I'm serious about this because there's a big move into health and all the information that's being acquired. So it doesn't really have to do with attention at all. And in that sense, if the concept is helpful for antitrust analysis, it's not going to be relevant, I don't think, to a lot of the coming problems. And if we're thinking about how do we judge these acquisitions, and you look at the kinds of companies that Google and Apple are acquiring involving information about health, we've got to think about that. Although John would prefer we pay more attention to attention than data, we have to think about that in terms of data. And so we can't really ignore the importance of data and, say, well, attention's way more important. Maybe they're both important, but someone said to me the other 2 days ago, data is so 2019. Maybe, but not to these big companies. It isn't. It's so 20, whatever it is in the future. One of the questions about the paper is whether John wants to go big or small. And in this sense, John tries, and I mentioned this before, and I think this is a very useful part, to cut down the scope of what we're talking about for attention. So he's looking for attention that involves, he calls it either market signaling or non-market signaling. It's part of, in a sense, a transaction or a bargain. So you can think of Spotify, that we pay attention, or YouTube to things, and we know that the deal is they're going to get something from us, we get something from them. It's part of a market transaction. There's a whole bunch of advertising. He mentions billboards, where it's sort of thrust on us, and it's not a transaction. It's not market signaling. Of course, when he mentioned billboards, I thought of, you must have thought, it's 3 billboards in Ebbing, Missouri, that really happy movie. So Francis McDormand wanted us to pay attention, but it's not the kind of attention that he's talking about. So that's a very focused way, and I think it's useful. This is in comparison to maybe how Tim Wu, in his current article in the Antitrust Law Journal, is talking about antitrust blind spot and talks about attention maybe too broadly. That's the focused aspect to it. The concern I have is, in a sense, whether there's mischief in the concept. And some of the cases that John referred to, I would be a little more cautious about, like the NAB agreement on ads. I don't think they did it so that we wouldn't eat more hamburgers and be more healthy. My guess is they did it so they'll avoid giving consumers information that might help them make choices that are sort of more, pricing that is lower. I mean, there's some economic reason for why they did it. And you might think of other cases where that sort of analysis, National Society of Professional Engineers, well, we don't want cognitive overload. John has really interesting articles that he points to about cognition, and it's very interesting, but the cognitive overload was giving buyers information on price. They should only think about one thing at a time, which was the quality of the engineering. We'll worry about the price later. So I'm a little concerned about where that would go. There's one of the hypotheticals was Google's acquisition of YouTube might be good because it allows you to lower the cognitive load, everything sort of in one spot. Not so sure about that. You might have opposed the breakup of AT&T, which increased the cognitive load on people because then they had to buy 3 products instead of 1 altogether. So again, I'm not certain where this goes for purposes of antitrust analysis. I do want to give a shout out for, oh yes, you're pointing to time, Eleanor, right? I agree. So I do want to make sure, read the stuff on free goods. It's in part drawing on a piece that John did before. It's very good. The discussion about how you should deal with two-sided markets is a good way of trying to, I don't say push aside, but getting us back to correct analysis for two-sided markets from the Ohio against American Express case. Finally, Three things to do. One is the Bundeskartellamt's decision in Facebook, which came out, I think, and finally was translated maybe after this draft. It deals actually with attention, the argument about attention, so I think that that should be in there. A little more about Tim Wu's current article, which also just came out about attention. And then finally, there is a chance for a radical restructuring of what we mean by consumer welfare if you think about the human personality from a different point of view than just buying things and paying money. What would it mean if you thought about our preferences for attention or not, and tying it into privacy? If we thought about consumer welfare not just from, you know, a monetary point of view, but from these other vantage points, maybe there's some greater, maybe it doesn't have to map onto our economic notion of consumer surplus and welfare, but some other different notion. So that's sort of my challenge for John, which is beyond my ability to think about. Thank you.
Our third paper is by Professor Alminas Zaldokis. He's Assistant Professor of Finance at the Hong Kong University of Science and Technology, and his main research focuses on the interaction between firm decisions in financial markets and product markets. He's looked at things like leniency programs also, and the unintended consequences, which can include increased merger activity. And he has also looked at how corporate disclosure practices like earnings calls might facilitate tacit collusion. Commenting on his paper will be Professor Daniel Sokol of the University of Florida Levin College of Law, and Professor Sokol focuses his teaching and scholarship on complex business issues from early stage startups to large multinational businesses and everything in between. Professor Zaldokis?
Thanks so much, and thanks for including this paper. I really enjoyed the mix of the legal papers, legal literature, and the economics here. So this will be a paper that's more based on the methods that we typically use in finance or economics in addressing what I think is an important point for corporate governance, thinking about corporate governance and the implications of antitrust on the on how firms should think about corporate governance. All right, so as was pointed out just now, this is a very sophisticated antitrust audience, so I will not go through the economic models behind it, but let me just motivate it very briefly where we're coming from with this line of work. So think about the simplest, 101 room to grow strategy. Firm decides to collude or deviate, either collude among profits perpetually or undercut the cartel members. In the end, it all depends probably on some sort of a discount factor. And this discount factor might also be different when we have different levels of antitrust enforcement. Now, is the firm that we typically, firm is modeled as a decision maker in most of these IO industrial organization literatures, but the firm is not a black box. We know that there are principals, there are shareholders that have discount factors possibly different from the managers, CEOs, or even middle managements who make the decisions whether to engage in the collusive behavior or not. So this paper looks into empirical evidence. There's no normative implications here, just a positive documentation on the corporate governance implications of prolonged market collusion. And what we try to see is whether firms adapt their executive compensation schemes when the collusion presumably becomes more appealing to the shareholders, to the principles of the decision-making process. Why would you think, what are the reasons, these two reasons why these discount factors might differ? One of them would be that even without antitrust enforcement, when we think about these shareholders and the firms, we sometimes even think of the infinite horizons And maybe, you know, from the shareholder perspective, this is not untrue. Shareholders might sell to someone else, and in some sense, this might, the shareholding itself might live infinite lives. On the other hand, CEOs, managers, or whoever's making decisions might have shorter term incentives. There's some career motives. There might be some, concerns about retirement and so on. So the discount factor might be lower for the executives who are not living infinite lives, not before the Google invents all the healthcare benefits and so on. Anyway, so with the antitrust enforcement, this becomes even more complicated because, as we know, at least in the U.S., executives might have criminal liability if they have the direct knowledge and engaged in the collusive behavior, explicitly collusive behavior. Now, when we're thinking about this project, we're thinking more about the shareholding structures that have many smaller, small shareholders, maybe some index funds, maybe just atomistic individual retail investors, rather than sort of block holding structures like Talman being indicted in the Christus Sotheby's case. So these anonymous shareholders might not be directly instructing or having the ability to directly instruct the executives to engage in collusive behavior, and so there's no way they can have any exposure to any criminal activity. So especially when we started thinking about this project, we noticed these trends that the corporations are getting fined for antitrust violations a little bit less compared to especially when the leniency program was strengthened in '93. However, when we look into the individuals that are being prosecuted or fined, the trends are slightly different from when you look into the number of corporations that are getting convicted. So what we try to do in this paper, we try to open this black box a little bit, and we take the case when antitrust enforcement has become weaker, at least for certain U.S. firms, and this, we argue that made collusion presumably more appealing to them, or at least the exposure, the cost of entering collusive agreements are lower because of weak enforcement. And we examine whether these changing incentives for shareholders made the firms adapt their executive compensation strategies. And in particular, we're looking to two particular features of executive compensation, and one is the relative performance evaluation, and I'll briefly explain what I mean by that. And second is equity compensation as a fraction of total compensation, which we think is one way how we can capture the long-term horizon incentives. So let me start with the relative performance evaluation. Just a quick reminder of the finance literature on this. The theory would say that rewarding CEOs based on their performance relative to the peers can help establish incentives. So with relative performance compensation, you would take out sort of industry shocks that the firm is facing from the firm's performance, and in this way, you're just rewarding the executives based on this extra component, how the firm outperforms the industry peers. Now, typically, the literature has found that the COP is on average positively associated with their own performance. So the firm is performing well, CEO is getting paid more. Negatively associated with the peer performance, that is, if you're outperforming the peers, then you're getting to be paid more. However, if you really want to soften product market competition, maybe you should have not a negative weight on the peer performance, but you should have a positive weight on the peer performance. So, in terms of the relative performance compensation, the contracts, the CEO executive compensation contracts, would typically even state the firms to which the peer firms to which the firm's performance is measured. And there are two types of benchmark groups. One is the general benchmark group, general compensation benchmark, which is pretty much like labor market concerns. If you're a large firm, then you want to benchmark your pay to another large firm. But this is not necessarily in the same industry. It simply reflects the possible career incentives of the executives. Now, the relative performance group is the group that you are supposed to outperform to get the extra bonus. And most of the outperformance will be based not on the formulas that are described in the compensation contracts, executive contracts, but informal board decisions. So over half of the cases would be just informal decisions. Actually, this is something that we started looking at a couple of years ago, and then not proceeded too much with it. Just looking into what happens in the during the overlap of the collusive arrangement. This is only convicted cartels in the U.S. And we match it to all this data on the executive contracts. We looked into what type of contracts these executives had, and out of the 416 cases, firms that we could match. So during the type of cartel, we want to check whether the other cartel peers of the convicted cartels were mentioned in the compensation benchmark contracts, and we found that in the 20% of the cases, the cartel peer was mentioned in the general compensation benchmark, but only in 10% of the cases, they were asked to be outperformed. Okay, so this difference in these two numbers is already interesting because while the firms were aware that these are potentially could be included in the compensation contract, they did not want to include them in the group that you should be outperformed. However, if you look outside of the cartel period, the number actually increases to 23%. So outside of when they were engaging in the collusive activity, they would include those peers in the outperformance group. Anyways, but I'll talk about the issues with this in a second. In terms of the second measure that we're looking at on the horizon, it's a little more tricky. Most executive contracts are at will, so they don't have like a 2-year or 5-year horizon, but can be terminated at will. And even if you somehow want to estimate the average duration of executive compensation contract based on the option exercise data, most of them just have a very short duration on average. So we instead want to look into that from the perspective of maybe equity compensation. As the stock market anticipates the future losses from the punishment phases, sorry for the typo, and that should be reflected in the stock price. So if we give more equity compensation, it aligns more incentives between the shareholders and the executive. All right, so of course, with the data that I showed on the relative performance compensation, and even if we just looked into the convicted cartels, on whether they engage more into equity compensation or not, the issue would be that looking only at the convicted cartels might be insufficient, as this is not a representative sample of all collusive arrangement. And in fact, if you're not observing the convicted cartel, whether these might be the firms that are engaging in most profitable collusive arrangements, or could be not engaging. So this control group is really tricky to handle. So instead, to draw some of the causality arguments, we'll look into one particular regulatory change, which presumably made the collusion in some local markets less costly. So in particular, 2013, DOJ closes down 4 of its 7 regional offices that dealt with the antitrust enforcement: Atlanta, Cleveland, Dallas, and Philadelphia. And some of this coverage was passed through to the other regional offices, but most of it, to my understanding, was moved to the DC offices. It was argued, at least in the media, that it was primarily driven by the budget cuts. Analysts considered that this made it harder for DOJ to police regional cases. Instead, they would rather focus and put those resources into this, as they said in the media, policing these big tech cartels, looking into bigger tech cases. All right, so this was a little bit contentious. Cleveland mayor saying that closing Cleveland's field office will impair the DOJ's ability to pursue effective criminal enforcement of antitrust laws. On the other hand, DOJ says that they wanted larger concentration of lawyers in fewer locations so that they can investigate more sophisticated crimes. What we try to say in this, that this regulatory change would reduce the expected cost from antitrust investigation and change the trade-off of firms whether to engage in collusive arrangements. Which firms? Those that became really far away from the closest antitrust office, that we measure by just the change in the spherical distance, and those that have, in particular, those that have local peers to collude, that we measure just having headquarters within 200 miles radius and being from the same industry. So these are the field offices that were closed, and the states that were covered by them. Let me just skip that. And this is the number of antitrust cases from the affected states. So the darker line is the states that are affiliated with the field offices that were closed, and the lighter line is the number of cases filed in the states that were not, that did not have the experience the change in the distance to the closest office. So we see that there's like bigger drop in the darker line. Of course, it's hard to see without the confidence intervals here. All right, comparing the two sets of firms that we'll try to analyze. There's not too much difference in terms of the different observable variables, except for the size and maybe the gross profit margin that we'll try to somehow control. So our empirical strategy will be looking into two things. First, this relative performance evaluation. I mentioned that the firms often explicitly mention peers, but then many times the boards award the extra compensation for outperformance implicitly. So what we'll do that, we'll follow the literature and we'll just check whether CEO compensation depends positively or negatively to the own performance and the peer performance. We'll define the peers being local peers coming from the same industry. And then we'll study whether equity compensation changes and whether this somehow gets reflected in the some sort of proxy for markups will be gross profit margins. All right, so just a few empirical results. So let me start with the first one, whether the total compensation depends on the peer performance and on the own performance. And we don't show all the terms inside here, but basically what we argue is that if the distance becomes further away after the law has been implemented, then the firm's the CEO compensation becomes less dependent on their own performance and more dependent on the performance of their peers. So in terms of relative performance evaluation, the weight on the peer performance becomes slightly more positive compared to the own performance. And this holds even controlling for whatever happens in the industry trends. Let me just jump one step ahead. When we construct this this table based on the every single combination of firms, we can see that we can even control for whatever is happening for different firms at the same time. So the peer times peer fixed effects, the peer trends, or even the match between the two firms, the focal and the peer firms fixed effects. We see the same relationship that the compensation becomes more dependent on the peer performance, which is opposite of what the literature has found before. All right, where does this primarily come from? Actually, it comes from the cash compensation rather than equity compensation, and we know that cash compensation is much more discretionary in terms of how the board decides how much to give it at the end of the year. Right, so this is the first set of the results that I wanted to show. The second one is that the CEOs actually, after this law gets passed, and if they have local peer firms, get awarded more equity grants as a fraction of the market capitalization. And equity versus options, we see the same result there's an increase in how much the CEOs are given equity compensation, which makes them more in line in terms of incentives with the shareholders. Does this work? We'll look into the gross profit margins as a proxy for the markups and see whether there's a differential effect if the firms have if the CEOs have been awarded these equity grants or not. And we try to do this sort of a triple interaction, quadruple interaction. We see that for every stock option grant corresponding to 1% market value of the firm, gross profit margins are higher by 0.5% after the policy change. So just to conclude with a few of the robustness checks, we try to anticipate this by a few years, sort of see whether there's a general trend, sort of placebo test. We don't find an effect. Try to redefine the industry in many different ways. We don't find an effect. Some of the results that were not in the paper, just got them last night. We see a stronger results when the firms have a sort of stronger corporate governance structure to start with. So that is like they have fewer co-opted members, and stronger for CEOs that are closer to retirement age. We also saw kind of passing. Let me conclude. Shareholders might be interested in setting incentives to motivate managers to pursue collusive strategies. So they weren't doing so. They're not giving direct instructions to collude, and there's a plausible deniability that the incentives do not reflect this particular product market strategy. So maybe this is more like a implication for the corporate governance literature than antitrust. But if long-term behavior facilitates collusion by aligning incentives between shareholders and the executives, maybe the policies that care about consumer welfare might want to encourage more short-termist view rather than a long-termist view of the managers. Thank you. I look forward to Danny's comments.
Thank you. For those of you who know me, I tend to walk around, use my arms, and they might even flail a bit. I'm going to try something different. I'm going to try to stay seated to see if it's like a different me. Because, if to John's paper on attention, maybe a different medium might lead to different kind of attention. So literally, I'm sitting on my hands as best I can. So I think that this work is very important. It's part of a new wave in empirical work, particularly in financial economics, but not exclusively so, focusing on opening the door to the black box. I'm going to try to also say, it's in my hand anyway. Okay, I can't. So it turns out that as best as we try, we can't change who we are. And there's actually a nice little motif that goes to the paper as well, which is that a lot of this goes to human behavior. And Alminas is absolutely right in noting that so much, the field of IO is about the study of firm-to-firm behavior. And a lot of the antitrust law scholarship is really focused on firm-to-firm behavior. And now as we see increasing attention paid to incentives within the firm, my hope is that this opens up a whole new area of antitrust to compliance, and I'll talk about why that matters specific to NYU in a second. I'll say the other area where we're seeing this, but in a slightly different context, bring it together, I want to highlight the work of two people at the Manesh, who has a wonderful recent paper in the Antitrust Law Journal dealing with partial ownership. Scott's paper, it's working paper format, also focusing on corporate governance and partial ownership and its interface with antitrust. So my hope that we're seeing a next generation of a different sort, focusing on corporate governance and antitrust. So I think compliance matters. So what is the policy implication number one? I believe at this very institution, Makan Delrahim gave some comments in July, noting, it is important, however, that the Antitrust Division's practices and policies evolve to ensure that we have the right framework for maximizing deterrence and detection. We recognize that progress has been made over the years in antitrust awareness, increased compliance, and want to encourage companies to further invest in compliance efforts. It's a good speech. It was really the first significant shift in DOJ thinking formally in this area, and I think this paper is bringing a lot of attention I think the DOJ hadn't thought about. And I think that this also helps in policy implications another way. Again, we've been thinking of incentives across firms. Most of the work has been theoretical within firm. This is one of the first tangible papers of looking incentives within the firm and thinking about agency cost, and we'll get back to that in a second, within the firm and how this might impact antitrust. So the basic question that Alminas also answers is, do the field offices and their closures seem to matter? The answer is yes. I like that because, at the 2012 version of this conference, Harry presented a paper on exactly that point. So it goes to show you that, and that was at the time looking at the aggregate data collected from DOJ. Number of cases went down after they closed the field offices. And here we get much more nuanced data about exactly how that worked. But I'll come back to that in a second. So I'm going to talk about something which actually channels me back to 2012, that last generation, when Harry first asked me, are we measuring the right things? This goes to show you when Harry says something I really do remember years later.
I don't, but that's good.
So the first thing I'd note is that we have multiple principal-agent relationships within the firm and frankly within the organization, because there's a shareholder to director and a director to senior management and senior management to lower level management to just, the people that bring you coffee in the afternoon. And I wonder if one thing we might be thinking about is, are bonuses set the same way for CEOs and others in the C-suite that may actually be different in kind than the bonus structures being set for division heads, the heads of marketing, sales, the people that go to jail for collusion. The second, I actually wonder, do we have a traditional agency cost problem? So this was one of the major transformative papers thinking about agency costs in the 70s, Jensen and Meckling. In the finance literature, the problem there that they identified is that, the principal and the agent's incentives may not be aligned, so we want to better align in the incentives. And that might work for certain kinds of corporate wrongdoing, like audit fraud, where long-term you're hurting the company. But it's not clear to me that that's the situation happening in antitrust, which actually was the 2010 paper. Thank you also for that one, Harry. And the reason I say this is because I'd say antitrust looks a lot more like anti-bribery. If you never get caught, the firm is actually benefiting on some fundamental level, right? It's not like, all this audit fraud means that the firm is being harmed and eventually will come back to haunt you. If we never detect, we might never have known that the real reason we had all these sales was because either bribery or antitrust. And I think, therefore, this goes to, if exec pays to try to solve the agency cost problem, I don't think that if companies are smart, they really want to solve that problem. Except you'd say, but wait a second, we have something else. What about fiduciary duties, which was, by the way, missed in that first Schmaltz paper in the Journal of Financial Economics. So here, the fiduciary duties is a very interesting one. This is basically your oversight duty, and we've seen literally only as of this summer 2 important cases that make us think much more carefully about oversight duty in Delaware courts. But basically, from Caremark till around this summer, it was really difficult to have any kind of significant risk with regard to oversight duties. And in fact, the one case I can think of where there was a real duty of loyalty breach for oversight duty, the Delaware Chancellery Court decision said something along the lines of the brother-in-law who was supposed to be having oversight was a, quote, stooge of the CEO. If that's what it takes to violate duty of loyalty, if that's normally a check, we don't seem to have it here. So fiduciary duties matter, except that they don't. So the optimal strategy for the firm is actually get really close to that line for violating fiduciary duties, but not quite get there, because they actually understand that, this is not a crime that hurts the company. They are still maximizing shareholder value. Now, that's a big framework question. The other thing I wonder is the local office aspect. So fascinating results, but I'm going to push back on some of them. So this only matters if there's somehow information leakage from companies to the local authorities that you wouldn't get with a DC field office, a DC office or New York field office or San Francisco field office. So here's the question. Let's say it's two companies within 100 miles of each other, but the collusion is actually, not happening anywhere near the corporate headquarters, and in fact, people at the highest level, they're not turning a blind eye, but they're not really investigating all that much. How does that information actually get to the local offices? How would that get to Cleveland or Philadelphia? So that's not quite clear to me how, what that information mechanism was. So I think you have to tease that out more. So what might we measure differently? The first is how much of this is a corporate governance problem at the board level. And here I suggest a very rich literature in financial economics, to a certain extent also a little bit in the accounting literature, that focuses on executive compensation and board of directors generally. And now I want to tease out a little bit executive compensation more, even more than Alminas did. So there's long-term and there's short-term executive compensation in the following sense. Some of the option grants or some of the equity-based pay is based on different time horizons. Some is based on that year's performance. Some might be based on 3 or even 5-year performance. And the reason why that matters is the longer the time horizon, the less it's going to be tied to collusion, because the cartels might break down. I'd also say, so it's interesting when we think about executive pay, here's a question to ponder. If you're going to be paid more, and this is where incentives do matter, if you're going to be paid more based on how you outperform your peers, that suggests that your personal incentive, regardless of the mid-level managers, you want them to collude, but maybe not so effectively. Why? Because all of a sudden, if you're doing so much better than your peers, then it's a function that somehow you basically defected from the cartel for a certain amount of time. Now, the reality is we know that cartels break down. I believe vitamin C, the cartel technically was on and off 40 different times. And so, again, this plays to the time horizon issue. And something that he's now corrected with the paper that I suggested is exec compensation. I wonder if the executive compensation people understand antitrust markets the way we understand antitrust markets. So they have a market definition problem. Who is your comparable executive? That might look different than the traditional NCIS code, and so the version he uses now, which is really good, is the text-based network industry classification, where they do textual analysis based on securities filings. That's great, but even that may be different than what you at the agencies are seeing that actually gets put in for what kind of primary business are you in. But now let me make it more complicated. Let's say the collusion's not happening in your primary business. Maybe one of the reasons why the collusion exists is because the mid-level manager is in, essentially not the 80% of the business, not the 10% of the business, but that smaller component of your business where you just don't pay as much attention to them because it's not the high-growth business, and therefore it doesn't seem to be cutthroat. Well, how does that play out with conglomerate firms? It's just something to raise. I don't think that there's an easy solution to it, but it's something to note. So how might we theorize differently? So there's a paper that Alminas has, and then there's one that we heard earlier with regards to Ben Layden in the first session about what is potentially tacit collusion, maybe a little bit more with regards to signaling. And I wonder if there may be signaling some kind of hub and spoke where actually it's the exec compensation consultant who's essentially signaling to each of the companies, how to set pay. A few quick things, and I'll just quickly wrap up. Number one, does executive compensation corporate governance work differently in publicly traded firms than private firms? Does it look different from non-US firms where corporate governance, particularly in some of the countries where you see lots of cartelists, not to give names, but say Korea, where you go from literally sitting in jail to joining the board of Samsung all in the same week. You know, when corporate governance standards are different, I wonder if we see an effect there. What about, you know, do we see some kind of effect that looks different for the leniency applicants in each of these cartels, right? Does their corporate governance work differently? Finally, going to something which I think you could look at, how does the membership of the Executive Compensation Committee play into this? Are there certain attributes specific to that committee in terms of corporate governance that might shed light? Thank you.
Okay, and our final speaker is Catherine Forrest, who is known as an expert in legal issues and technology, a former United States District Court judge in the Southern District of New York, and also Deputy Assistant Attorney General in the Justice Department.
In the antitrust area, yeah. And I'll make it quick because I know we're running over, so I've actually taken my remarks and I'm going to reduce them down, I think, to sort of 1 point for each of the papers. First of all, I think that the work that is being developed here is just really excellent, and there's a lot of very good thinking that's going on right now, which is impressive and encouraging. One overall theme that I would say is we need to ask ourselves what the policy implications are for actually doing some of what each of the panelists have said. And for the merger paper, Mr. Patel, what I would ask you is the extent to which our markets today our financial markets rely upon a concept of certainty. And there is a great deal of breakage that occurs when you try to unscramble the eggs. Not only is it difficult to do, but if you were to have increased attention to unscrambling eggs afterwards, a lot more investigations of mergers after they had occurred with a lot more attention to the possible imposition of remedies. What you would do is inject an element of uncertainty into the business environment that does not currently exist. And I would argue that that could have a waterfall effect that could be quite significant. The other issue in the same vein is there's a give and take during the merger review process, which is that there's a bargain that the parties engage in. They bargain for time. They bargain how much time they're going to get to review documents, how many witnesses they're going to review. They're going to bargain over the remedy. And one thing I think that your paper doesn't really deal with is what about all of the remedies that occur sotto voce, that occur through the initiative of the merging parties that aren't necessarily part of a consent decree? And how do you take those into account? And what about mergers where there have been remedies? So in other words, afterwards, you've got a situation where there could be, I think, under your scenario, a second bite at the apple. They've gone through their review, but they get to do it again. So I would just sort of say there's a policy implication. Let me go on to the next paper, which is for the attention markets, which I think is very interesting, and I think that it's a very interesting proposition that more consumer choice does not equate with consumer welfare, because of course that's a central tenet of antitrust law. But I do think there's a question as to whether or not what you're suggesting with attention actually changes very much from eyeballs. Is it really very different from how audience is measured today? And what would the economists be doing in the antitrust division when they're going to sit there and they're going to look at attention? How are they going to measure that? They're going to measure it with time, right? Potentially, that's eyeballs, and audience, it's eyeballs. And they're going to worry about data. And they're going to worry about the utilization and the monetization, ultimately, of data. So I think what you've got as a premise, Mr. Newman, Professor Newman, is very interesting, but I wonder what the actual economic modeling implications are. And so I would encourage you to model something out as part of your paper and to suggest how it differs beneficially over modeling with eyeballs and data, which is the way it would be done today. And I think that would actually enhance it greatly. In terms of the last paper for the motivating collusion, I also found it very interesting. I think, again, you have an issue about the ubiquity of a particular practice and what are the competitive implications of it. There is performance-based compensation in place all over this country and other countries all the time these days, it has increased. And so one of the issues with the regression is it doesn't necessarily account for a market-wide increase in performance-based compensation. So you'd want to be able to tease that out. The second piece is that the antitrust, the divisions that were closed, and I happened to be at the division when we were considering the closures, the time frame, again, is a bit of a question mark because it takes a long time to do an investigation on collusion. You don't just do it between the time a practice is implemented, for instance, closing an office, and 2 years later, and suddenly have a measurable impact. Usually, and your data set is actually 2008 to 2014, and you use it across all of your, most of your regressions, I think, for all of them in any event. We'll talk about it afterwards. But the, one of the issues is whether or not you've embedded enough about how long it takes to do a collusion investigation, because it does take some time. So you want to build in that lag. And lastly, you want to, I think, to make it ultimately more effective, compared to DC. In other words, if you're showing a collusion effect, and you're showing a collusion effect in particular geographies because of the absence now of certain enforcement offices, and you're able to show an uptick, what you'd want to show is a measurable difference in the geographies where there wasn't a closure, and that would be DC, for instance. And I think that, if it worked out in terms of the data, could be very effective. So those are my points. I hope I didn't speak too fast. I thank you for your attention to my remarks, which made it worth my while being here today. Thank you. And by the way, I just think, again, the papers were terrific and the remarks were really enjoyable to listen to. As a non-academic, I feel a little bit like I'm an imposter up here, sort of listening to all of this great work. Appreciate it.
Thank you all, and I think we don't have time for questions right now, but perhaps you can approach the panelists during the break. Thank you.